forum about Singapore's Foreign Interference Countermeasures Bill. My name is PJ Thum. I'm New Narrative's founder and managing director, and I'm wearing a blue and white batik shirt and standing in front of a big bookshelf. My pronouns are he, him. New Narrative is a member-supported movement for democracy in Southeast Asia, and if you find this event useful and would like to see more, please join our movement at newnarrative.com/join or donate at newnarrative.com/donate. As we'll be talking about in a second, this may actually be your last chance to support New Narrative, so please do so right away if you believe in our work. Joining us today, we have Carol Yuen, a lawyer with Peter Low & Chu LLC, Leong Man Wai, a non-constituency MP for the Progress Singapore Party, and Wendy Low, leader of the PSP's Women's Wing and also an intellectual property lawyer. Unfortunately, Hazel Poa is ill and is unable to join us this evening, and we wish her a speedy recovery. Now, as all of you know, the Foreign Interference Countermeasures Bill, or FICA, was tabled in Parliament just over 2 weeks ago, and we assume that the PAP government intends to pass this law on the coming Monday, 4th of October. Now, this is a massive 249-page bill. It's a small book, really, and it's being rushed through Parliament with unseemly haste. Consequently, there's been a lot of public confusion about this bill, and so we've put together this public forum for you to talk to a lawyer who has studied the bill and to two politicians who are represented in Parliament and who will be addressing this bill from their perspective. And we invite you to start putting your questions into the chat, where our producer will pick out your questions and pass them along to our panelists to answer. Feel free also to discuss between yourselves in the chat on YouTube and Facebook, but we do request that you be kind and respectful in your comments. Remember, we are all living through very difficult and stressful times. Now, a lot of the commentary about this bill has been published in the last week, and it talks about the significant problems with the bill. And so I will begin by summarizing the main issues before we go to our panelists. So the main issues that have been highlighted about this bill include, first, that the bill doesn't actually make much sense in how it approaches the problem of foreign intervention, because in other countries which try and deal with foreign intervention, the laws logically focus on the people with the power to actually change or influence the country, like elected politicians, right? And so these laws increase transparency and increase public oversight of these politicians. With FICA, on the other hand, the assumption is reversed, that it is private citizens, people who don't hold any power, who are the ones that need to be monitored, while the government, which holds all the power over the country, must be protected from private citizens. Now, second, FICA compounds this by instead massively increasing the power of one man, Minister of Home Affairs and Law, K. Shanmugam, with no meaningful oversight preventing him from abusing these new powers. What are these new powers? Well, the law actually has three essential avenues of attack to stop foreign interference. The first is that Part 2, which criminalizes foreign interference, but the definitions that it uses are so broad that it is virtually impossible to electronically communicate with a non-Singaporean citizen without then being in breach of the law. So whether you're a business person, politician, activist, journalist, or academic, you can almost certainly interact with non-Singaporeans in legitimate ways that nonetheless could be considered as violating and could lead to you to be prosecuted under this law. The second avenue of attack for this law is that it gives the Minister of Home Affairs wide-ranging powers to issue a whole bunch of directions, like POFMA, directions which do things like demand information, demand your private information, disable your access to social media, to internet services, stop the publication of information, all which can be done without any proof that you've actually done anything wrong. Likewise, the minister can declare websites like New Narrative as proscribed online locations, which then make it illegal for Singaporeans to operate this site, for Singaporeans to support the site, or to place advertising on the site, among other things, purely, and I stress this, on suspicion of foreign interference. And the third avenue of attack is Part 4, which gives the Minister for Home Affairs the power to arbitrarily designate any person or entity as politically significant, thus placing them under rigorous scrutiny, and he can even force you to stop associating with a particular foreigner. So the law even admits that this actually may restrict your freedom of association. And the implication of this is that they actually want Singaporeans to become politically insignificant for what, for whatever end. And of course, to top it all off, if you appeal against any of this, first you must comply, and then you can appeal. So effectively, you're treated as guilty before you prove you're innocent. Then once you appeal, you have to appeal first to Mr. Shanmugam, and then if he turns your appeal down, then you have to appeal to a secret tribunal run by the Ministry of Home Affairs. And these tribunals don't actually need to be all judges, just one judge, and they can summarily dismiss your appeal without your participation, without even asking the minister to defend himself. And even more unfair, the minister can can refuse to provide information to the tribunal on various grounds like national security, while demanding that you provide extra information to prove that your appeal is frivolous or vexatious. So there is no meaningful oversight because these you can only appeal to the courts on procedural grounds, and the courts can't rule on the merits of the case. So the brutal logic of this law is really that if the Minister for Home Affairs, can look into any transaction, peer into anyone's electronic life, or unilaterally block any website or delete any online information published, he can effectively stop foreign intervention. The same way dropping a nuclear bomb on a person will cure that person of any illness. But who watches the watchmen? And this is a central issue to this proposed law, that the potential for abuse is massive, and this law will turn Shanmugam into the most powerful man in Singapore. And of course, the PAP's track record suggests that foreign interference will be used as a pretext to restrict all rights and target independent media, activists, and opposition. Okay, so questions are now coming in, so please do post your questions, and we'll go to our panelists. So enough from me. We're going to start with a round of questions and comments from our panelists, starting with Carol. Carol, so you've studied this law, you're a lawyer. What's your opinion about the law?
So PJ offered 3 areas of the bill to look at, and I'll just give brief comments on each of those areas. For the first one, he mentioned about how there are offences for acting on behalf of a foreign principal. There are offences for engaging in certain covert activity or activity involving deception on behalf of a foreign principal. And this foreign interference can become an offense if one person has the knowledge or has reason to believe that such material or information that's being published in Singapore is likely to be prejudicial to the security of Singapore, prejudicial to important aspects of Singapore like public health, friendly relations of Singapore with other countries, incite feelings of enmity, diminish public confidence of the government, and also importantly, if the activity is or is likely to be directed towards a political end in Singapore. And you will notice that this phrase, the activity being directed towards a political end in Singapore, it is very broad. And indeed, the definition in the bill is also very broad, that directed towards a political end in Singapore can mean that it promotes the interests of a certain political party, it influences Singapore governmental decisions, influences proceedings in parliament, which you can sort of think of as electoral democratic processes, governmental processes. So in a way, they are important to have as our own. But the thing is that political end in Singapore also includes matters of seeking to influence matters of public controversy and also influencing political views. So it seems as though it would also affect discussions between Singaporeans and foreigners of political issues in Singapore. And you would think that in the normal course of things these days, you will have a lot of engagement with foreigners and you will share ideas. So that's something that this offences provisions might potentially cover. And the way that covert is defined in the bill is that what acts are lacking in transparency can also be defined as covert. So to not fall afoul of being involved in covert activity, it's important to be transparent about the acts that you do. And the next area that PJ talked about is about directions that ministers can give. So these are for directions against electronic communications activity that a person might engage in. And the minister can, if the minister suspects that the activity is being undertaken on behalf of a foreign principal, can implement a direction to ask for the communication to be stopped. So then you would have to remove, let's say, a Facebook post. There could also be a must carry direction, which means that you must indicate a certain message on the post, that there is some foreign principal involved in the post. It could also involve a disabling of accounts, as well as access to the social media platform or online platform. Now, to appeal these directions, you have to go through the minister, and then it goes to a reviewing tribunal. But the thing is that because there are considerations of national security or public interest involved in the decision-making of the minister, there is actually a provision in the bill that enables the reviewing tribunal to not disclose all the information to the person who is challenging the direction. So in that sense, the person challenging the direction might not have all the information to do the appeal. And this is on accounts that, certain information that's released might be against public interest or against national security. And also, aside from this bill, there is also a public interest privilege in communications between public officials. So there is a difficulty in securing certain information. On the other hand, though, the person who challenges the direction may have to make disclosures about the possibly about the post that the person made. It's not so clear yet what kind of disclosures this person has to make, but the bill does say that the tribunal can require this person to make disclosures. But the rules only come later when the law is implemented, and the ministry can then make something called subsidiary legislation, which are regulations, but they are also laws. So they can mandate that the person challenging the decision will have to make certain disclosures. So in challenging the decision, you might actually have to give more information about your activities with the foreign principal. And another point to raise at this point is that foreign principals are defined very broadly, so they include any foreigner, any foreign entity. And this is actually different from a very similar law in Australia, which also Australia a couple years back implemented foreign interference offences, and I think they might be one of the only countries to do it. But for them, foreign principals are foreign government-related entities or foreign government-related individuals. So the foreign government actually has to exercise total or substantial control over that foreign individual. So in that sense, it is really much more targeted at foreign governments trying to influence the Australian activities. But in the case of this bill, although the MHA has said that it's targeted at hostile information campaigns, the language of the bill does open up to cover a lot of activity that involves these foreigners. So for people or for organizations like NGOs that have a lot of interactions with foreigners, that's something to take care of. And also, this relates to the third area, which is on politically significant persons. Previously, under the Political Donations Act, Political Donations Act would cover political associations, which are political parties, and also associations that have their main purpose as the politics of Singapore. But I think the definition in this current bill opens it up much wider to include people who have activity that are directed towards a political end. So this involves a lot of activities which also are related to issues of public importance, public controversy. So really, who gets designated a politically significant person, that is a very open issue, and it gives the minister a lot of discretion to do so. Those are the comments I have for now, and looking forward to all your questions.
Thanks, Carol. One quick question from the chat, just pretty factual. Can a foreigner be designated a politically significant person?
I believe it's meant to designate locals, but I don't think the language of the bill precludes that.
Right. Okay. And another question that's coming very quickly. If I send a WhatsApp to a foreigner, because it's an encrypted platform, is that sufficient to meet the covert or deception clause of the offense of section 17 or 18?
So you actually have to be undertaking activity on behalf of the foreigner, which involves some form of collaboration. So
right, those are the other clauses. I mean, this person is just asking about that fourth clause. What is the level for what is considered covert? Is merely using an encrypted platform covert, or is it, is there a higher bar?
So if we look at the explanatory part of this bill, it gives an example where a person is trying to deliberately move to an encrypted platform in order to make their messages more hidden or more covert. So if WhatsApp is being used, that might not be such a covert move, in that there was no deliberate move, because WhatsApp is a very common platform. So in that sense, that fact alone will be very difficult to say that the activity was covert.
Okay, thank you. Okay, let's turn to so Manwai, I understand you're carrying a petition to Parliament. Could you tell us more about that and about the PSP's position on this bill?
Okay, thank you. Yes, this morning I submitted a petition on behalf of some civil organizations. PSP believe that as parliamentarians, we should also help the views and opinions of the public to be reflected in Parliament. But of course, not all the time we can submit petition. But this is a very important bill. And so the first thing PSP is going to approach this from 3 areas. One is why the bill is rushed through Parliament. And this essentially is also the basic request for the petition that has been submitted in Parliament today. Why the bill was tabled on 13 September, and next Monday, this coming Monday, it is likely to be debated in Parliament already. So after the second reading is this Monday, and then after that, very likely the third reading will also go through the Parliament at the same time, and then the bill becomes law after Monday. So it is only a lapse of 3 weeks, very little time, and even the parliamentarians do not have enough time to actually look at the bill and consult the experts. What we think is that the bill should have a proper public consultation process, and then also refer to a parliamentary select committee. These are the two main things that the petition submitted this morning requested the government and the parliament to do that. So we think that there should be respect for the due legislative process and not rush through the bill. The second area that PSP is concerned about is also that this is a very critical time for Singapore. The COVID situation has worsened so much, and the jobs and livelihood problems of Singaporeans is also worsening. So this is really not the right time to table such an important bill. There should be enough time for Singaporeans to sit back and think through the implications of the bill. before we pass such an important bill. And over the years, the governments have enough tools and enough budgets, resources to actually tackle the national security problems of Singapore. And there's no really immediate threat to our security. So actually, we can afford to have some more time to deliberate and to consider the bill. So this is a second area that PSP has doubts about. And of course, the third area is that this bill, although we are not going to talk about the pros and cons so much, because we are asking them, that means the government, to respect the due process of legislation first. But nevertheless, looking into the details of the bill, and just now Carol has shared with us, Carol and PJ has shared with us some of the essential points of this bill, and we found that it is totally against the founding principles of Progress Singapore Party, PSP, our party. Our founding principles are transparency, accountability, and independence. So if a minister has the power to actually implicate somebody by just suspecting without any evidence, what kind of transparency are we talking about? In fact, what kind of justice are we talking about? What kind of rule of law we are talking about? Secondly, and when the minister still can exercise that kind of power, and the only check on him is not a court, but actually a tribunal. And the tribunal is actually appointed by him. So what kind of accountability are you talking about? And thirdly, lastly, of course, in the whole process, the court is being left out of the whole process. They are able to come in only on procedural issues, but their position is basically substituted by the tribunal. So the whole separation of powers, principles behind democracy, independence of one branch of government vis-a-vis the other branch, the whole principle is being, in a way, thrown away in this bill that's coming to us. So PSP found that the substance of the bill really is against the founding principles of our party. That's why our party will be doing what we can in Parliament on Monday to actually delay the bill, to ask the government to allow more time, more deliberation, both in the public and also in the select committee in Parliament, so that we can arrive at a solution that will enhance our national security further and also not to intrude into the privacy of our Singaporean citizens. So PJ, that's what we have for the moment, and we look forward to questions from the audience. Yeah.
Okay, there's just one quick question. Well, no, I don't know if it's that quick, but one person in the chat asked if what the opposition as a whole are doing about the law and to raise awareness and oppose. And I know the Workers' Party has tabled amendments. Does the PSP intend to table amendments, support the Workers' Party amendments? Are you working with the Workers' Party or any other parties in order to address this law?
Okay, the amendment submitted by Workers' Party is their own effort. Okay, there's no deliberation between their party and our party, but we are of course, we are in constant contact with one another. The approach adopted by PSP, Progress Singapore Party, is to actually first tell the government and to respect the process first. There's a whole legislative process that we should allow more public consultation and also to go through a select committee and all that. So that's our main focus at the moment. We don't intend to submit any amendments. And we are also in touch with the other parties. They are in general against the bill, but the other parties have not also submitted any amendments. Yeah.
Okay. Wendy, let's turn to you. I mean, you're both a lawyer and a politician. We have a question here from the chat. Is it accurate to say the chances of success of challenging this legislation as unconstitutional is remote? So, both from a political and a legal point of view, what can we actually do?
So I think if we look at the Constitution of Singapore, which is under Article 14, and that deals with the right of every citizen of Singapore to his or her right of freedom of speech. But that's subject to the caveat under Provision 2 and 3. And under Provision 2, it deals with the limits which are set by law. And this is where laws may be passed to set such restrictions as is considered necessary or expedient in the interest of the security of Singapore, or any part thereof, in considering friendly relationships with other countries, public order or morality, and restrictions that are designed to protect the privileges of Parliament or to provide against contempt of court, defamation, or incitement of any offence. So generally, the provisions are quite wide, and even within the Constitution itself, it does provide for exceptions which may be passed through legislation as a curtail to the general right of freedom of speech. So if you look at FICA very broadly, there are certain provisions that do fall in line with the Constitution. But I do agree with what Carol has highlighted earlier, that some of the definitions do appear to be overly broad. And for these provisions which are overly broad, and in particular considering definitions of whether public interest directed towards a political end, and with that political end being views or matters that become the subject of political debate in Singapore, that seems to go beyond the ambit potentially of what may be constituted as security in the interest of Singapore, or considerations of friendly nations or with other countries, or any such other provisions that set out under the Constitution. So with that, I think now that there's an opportunity for debate, and as Manwai has rightfully put that, we should take the time to deliberate on whether the current bill as drafted would fall in line with the Constitution, which is the overriding legislation of the country. And we should be careful to make sure that the bill, if it's eventually passed, will not be viewed as unconstitutional.
Okay, so a sort of follow-up question from the audience for both the politicians, asking, so how do we push the government to consider more time, or to give more time to deliberate the bill, right? Given that it's rushed. So what helps? Do petitions help? Writing to your MP? What would you recommend for our, for Singaporeans who want more time?
I think, first of all, really it's public opinion, the reaction from the public. Like, for example, recently when we debated on jobs and livelihood, SECA, there was a lot more responses and reaction from the ground. So you can see that the government also came out with various responses, including ministerial statements and all that. So the whole process was actually dragged through many months instead of just immediately debated in Parliament. Yeah? So I think if the Singaporeans come forward and express their desire to have more consultation, longer period of consultation, and also for it to be subject to the select committee of experts, that they can call the experts and solicit more opinions before we arrive at a conclusion, I think that would put some pressure on the government to actually consider that. So, but if the bill is going through on Monday, what PSP will be doing in Parliament, myself, Hazel and myself, we will also be arguing with all, whatever we can to say that the process should be reconsidered, and so that the Singaporeans will be able to come to terms with it. So I think that is the main thing, the support from the Singaporeans, and as parliamentarians, we will do our best in the Parliament. Yeah.
There is another question whether you think can the Workers' Party and the PSP come together with other opposition parties to form a united front on this? Do you think that's possible?
I think we're always basically aligned. Okay, we more or less we are aligned. Although the Workers' Party has submitted the amendments, But I think the amendments are very important because they addresses two of the most important areas that we objected to the bill. Right, one is the lack of a judicial review. So they basically substituted the judicial review with High Court, and then not just minister's suspicion, but also with evidence. So they have tabled some important amendments, and I think there's very little likelihood that the government will actually accept the amendments. So in a way, they are attacking the bill from one angle, and we are asking the government to delay the bill. So in a way, our different actions are still aligned. I think in the end, if the government is going to try to push through the bill in the current form, I think, I can't be 100% sure, I can't speak for Workers' Party, but I think all 12 of us will be voting against it.
Okay, thank you. So we have a series of questions about the law itself and the consequences. So one technical question first, I think mainly for Carol. Can the mere usage of VPN services, that's virtual private networks, give justification for the preparation of covert operations under Section 19, right? Which is the section which criminalizes planning to or preparing to engage in foreign interference. So just by using a VPN service, would that trigger the covert or deception clause?
So I think when you are charged with a crime, it is up to the discretion of the prosecutor whether to charge you and whether it's in the public interest to do so, right? So I think this would involve a consideration of the activity that you're doing and all that. But I do think that if you use VPN services, that can be construed as an action in which you are trying to be covert, because VPN makes it harder to track your actions, to track the source of your computer, for example. So it could be construed in that way, actually.
We also had a question about the arrestable and non-bailable, because this law, the offense is arrestable and non-bailable. So does that mean if you are arrested under this law, you have to sit in jail the whole time while your lawyer is trying to prepare you, and you're charged, lawyer is trying to prepare you, prepare your defense to prove your innocence?
That would be the case if you don't get bail, yes. So you will be.
But it's non-bailable, right? So you can't get bailed.
Yeah, if it's non-bailable, yes. You can't.
Okay. So
Yeah,
I think
so
Ken did a video earlier today where he said you could end up sitting in jail for years waiting for your court case. Is that an accurate
yes, so that depends on how fast investigations go and how fast they charge you. I mean, from the moment of arrest, they can keep you in remand, right? So that actually happens to a number of drug offenders who take very long to have their investigations completed, because they need to try to source for other people involved in the drug operations, or to check the phones of the people, get complete forensic reports, try to decode certain secret messages, for example. So if the investigations take a long time, then yes, the remand period could be very long. And then there'll be time taken for the trial as well. It might not just happen in one tranche, but in a few tranches.
Okay.
Yeah, so unfortunately, that is the reality.
Right.
I just wanted to take this moment to be more specific about my answer to the earlier question about whether politically significant persons can be foreigners also. So actually, there is a more specific definition for that in the bill. And politically significant persons, they can be citizens of Singapore, whether they are resident in Singapore or not, or they can be any foreigner in Singapore. So basically, the jurisdiction is exercised on Singapore citizens and foreigners in Singapore.
And presumably entities as well. So Singapore registered, because there's also politically significant entity. So those are the same?
Yes, that's for the entities.
So if you're a foreign, say 51% owned, because like something like 64% of the nominal value added to our GDP last year came from companies which had at least 51% foreign ownership, and they operate in Singapore. Is it possible to designate those companies as politically significant entities?
It's possible because the definition in the bill says you just have to be a body corporate that's registered under the Companies Act. So presumably they will have some form of registration to operate in Singapore. I think the broader principle is that a country has jurisdiction over the people and the entities in its territory and also its citizens abroad.
Got it. Okay. So, question here from the audience. What are the biggest risks if the judiciary is bypassed and the Ministry of Home Affairs is given full power? And I guess question for all three of you here, what do you consider the biggest risks? Maybe we can start with you, Wendy.
I think it comes back to the principle of own self, check own self, right? Because essentially you have the ministry which are giving out certain directions, and there is going to be a question of the independence of that review tribunal if it's not subjected to a higher authority, which is the judiciary, to review its decisions. So I think at the end of the day, if the recourse for appeal is only limited to procedural irregularities, then I think there will always be questions raised as to whether or not there is a fair finding on the substantive merits of the decisions which are issued. And I think this would also have long-term implications, especially where if you're looking at politically significant persons, which incidentally is acronymed as PSPs. Hopefully that's not an overt reference to our political party. But then at the end of the day, with that very wide discretion that's given to the ministry and closer election, then there is a question of whether those decisions, even if rightly issued, actually can get the confidence of the public that they have been imposed with a measure of fairness and equality in light of the circumstances. So I think the danger of removing the judiciary as a counter check and balance is dangerous not only from the balance of powers, as Manwai has rightfully put forward, but also on the greater political implications of what it means for the ministries and the authorities when it calls for the imposition of these directives at times where your electorates are going to make decisions about how you're imposing those powers. So I think it comes back to our point that there are wider implications that should be carefully reviewed, and it would be actually unwise for parties, not even political parties, civil societies and general Singaporeans to really consider what would be the long-term repercussions if such a broad-ranging bill is forcefully pushed through in a very short time.
Manwai, Carol, would either of you like to add anything?
Whichever. Carol, you want to go first?
Yeah. So actually, the bill does limit judicial review, and it talks about how there's a clause in it about how the decisions of the minister are not to be challenged unless it's a procedural fault in the following of the procedures in the bill. That is what we call an ouster clause in law, and although it may seem at first glance that the powers of the court to review the decisions of the minister are indeed limited in that way, the actual case might not be that way, because the court has inherent powers to judicially review, and there are certain grounds that it can review on, and even if the law is worded this way in the bill, the powers of the court cannot be taken away. So actually, there are other grounds that the court may potentially be able to review the directions of the minister on, such as illegality. Let's say if the minister acts beyond its powers, maybe that the minister issued a direction on the basis that it wanted to target a certain online activity, and then it also wanted to target similar posts, but this similar posts, maybe the minister covered it too broadly. So then the minister wouldn't be exercising its powers in terms of targeting the post as well as similar posts in issuing the direction. That could be one way of looking at it, that the minister exercise its powers too broadly than the law allows. Another one is irrationality, that the minister considered certain information wrongly when deciding whether or not to issue the direction. For example, the minister issued the direction on a user that was not even involved in issuing the involved in putting out the posts, for example. So then that would be irrational because that user had no connection with the post being put out. So those could be certain ways to look at it. And another one could be legitimate expectations. For example, if the minister had given certain statements with regards to whether or not the minister will issue the direction, what constitutes behavior that will be covered under the direction, and the user or the social media platform tried to act in reliance on what the minister had said, and then eventually was still given a direction. So that could be something that went against the issuance of the direction could be construed as going against what the minister initially gave a certain legitimate expectation of. So that's one way that could be challenged as well. But of course, these are challenges that the person who's been issued with the direction will have to be willing to take. And, it involves quite an arduous process also to try to challenge on these grounds.
So just to clarify, Carol, if I were to hire your company to challenge these grounds, what is the actual cost we're looking at to challenge, to file a judicial review or some sort of challenge in terms of time and money and also court fees, right?
I think there is a certain public interest element to it, so maybe not that much as you would imagine. But I think in terms of time, a lot of preparation goes into a hearing. So I would say easily it would take us many hours, I think 100 hours.
And there's court fees, right? Those are non-negotiable.
Oh, I mean, this is a public interest case. So
okay.
Yeah, I think they would. Oh, you mean filing
not your fees, but the filing fees, yes.
Yes. Yeah, so yes, the person who's been issued the direction would be would have to pay those fees upfront, and it's hard to get it back because this is against the government. So I think you can't really get costs for this kind of cases.
Do you have an idea what they are? Like, are they in thousands or the tens of thousands?
So you would file a case to the High Court because this is a judicial review case. High Court fees are more expensive than state court fees. So I would imagine that it could come up to a few thousands at least.
Okay, thanks. There's a direct response in the comments from Terry, actually, who says, POFMA shows us that such considerations cannot be considered as protection against abuse of the powers of the law. And I think he's responding to a point you were making earlier. So what about the precedent set by POFMA about these directions? Does that actually tell us anything? Carol?
Oh, me?
Yeah. He was responding to you.
Political parties question. Yes. So I think we've seen POFMA used in a variety of ways, although it's been targeted in certain situations. For example, anti-COVID news or panic-inducing news is also been targeted at certain persons in the event of elections. It's really can be used in a variety of ways, I would think. And sometimes when the government deems something a false statement of fact, it could be the way certain things are framed, right? Also, so I would think that there is scope for a broad implication for this bill.
Okay. So there's a new question here. Oh, sorry, Manwai, did you want to answer this last question about the biggest risks if the judiciary is bypassed?
Okay, actually, the judicial review. This is something that, by right, should never be compromised. Okay, but I mean, in the case of our country, the executive branch or the party that is controlling the executive branch also have a supermajority in the legislative branch. So we can't stop, some of these things from happening. When you look at the laws, actually, you ask me, I'm a layman, correct me if I'm wrong, is that in terms of the judicial review, for example, it is already taken out in the, no, actually it's not taken out. We have ISA already, right, which you can arrest somebody, and then maybe have a judicial review later and all that. So what I'm trying to say is that the executive branch already have quite extraordinary power to actually arrest the suspects who are a threat to the national security. And in terms of the online thing, we have got POFMA already. So we really don't understand why there's a need to further tighten the stranglehold on the Singaporeans with this FICA bill. So and furthermore, this judicial review is being totally removed. So this is really kind of the ultimate, that the government is able to now actually really take out all the check and balances, and so with that, really, it will increases the power of the executive, and basically, like some people say, Singapore is a system of rule by law and not rule of law, because the executive, with their supermajority in the legislature, they are always able to come up with laws to restrict the actions of the citizens further. Okay, so that is what some of the experts in the market has lamented. So that's the system. So with this FICA bill, it's likely that will be further enhanced. And so with that, really, there will be more restrictions, and there will also be, the fear factor will also be heightened, that more Singaporeans will feel a bit constrained. Fewer people want to speak up and all that. I think if this law is passed, basically, I think we have developed some momentum in the democratic process of our country. If this law is implemented, I think it will set back the democratic process by another 5 to 10 years. I think the bottom line is that.
Thanks, Munmai. So there's a series of questions now about examples and clarifying, various scenarios. And I guess maybe I can start with the most obvious one, because New Naratif is our holding company is registered in the UK and we're headquartered in KL, even though I'm Singaporean. So would the lawyers like to comment, is what we're doing here illegal? Because these are encrypted streams, but then they're publicly available. Would this be considered illegal under FICA?
So I think it's a matter of prosecutorial discretion, like I said. Depends on what they think is in the public interest to charge based on what the offense sets out. I think for the directions which target online communications activity, which ask you to stop posting something or to carry a certain message together with the post, for those, you might want to consider the risk, but maybe you don't have to be so worried, because it's only an offense if you don't comply, and you can always comply and try to work out a problem later. But I think what you should be upfront more worried about is the offenses of clandestine foreign interference by electronic communications activities. So then those would indeed be what you have to worry about in terms of whether your activity is covert or involves deception. And I think you can try to be more transparent in order to avoid falling afoul of that. So then there will be less reason in the prosecutions or the police's investigations to actually deem that you were acting covertly. For example, if you're holding a private webinar with overseas NGOs, I think there is some covert nature in that sense, in the sense that you are hosting it privately, But if your collaboration is something that is more open, for example, you do say that you from time to time meet these NGOs and you post an update about it after or before, even without revealing too many details, because understandably you want to keep some of those details private. But I think if you try to reveal it in some ways, that could tilt the analysis in your favor, and I think that's what you want to try to avoid.
What about religious organizations? There's been another question here, because a lot of churches obviously are very global nowadays. A lot of religions are by definition, not state movements. So would those run afoul of the law?
So I think for religions, they might be subject to other laws, for example, under the Societies Act or the Charities Act. And I'm not very familiar with those legislation, but I think that you need to have a certain number of officers or committee members who are Singaporean. And I think for societies, all members must be Singaporean or something like that. So I think the provisions for preventing foreign interference in religious organizations might already be quite strong. So I think that's why this bill doesn't specifically look at religious organizations, but entities and individuals as a whole.
So what about a scenario which I've suggested may be possible, where Shanmugam suspects another politician of foreign interference and demands their personal information, and then uses what he's learned from that demand to then, and potentially, we're saying potentially, I'm not implying that Mr. Shanmugam is in any way corrupt or will abuse power, but is that actually theoretically possible that he could go to Manwai and say, hey, Manwai, I noticed that this looks kind of sketchy. It would be terrible if it came out, whatever it is, it's totally legitimate. But actually, he then uses this information to say that, Manwai, you should then vote, in favor of this government bill that's coming up. Is that theoretically possible? And would we be able to detect this scenario if it happened?
As in to use the person's information for an ulterior purpose.
Yeah, because there's so many clauses about the law saying he doesn't have to disclose what he's doing with the information, or or even that, I think, if I remember, like under the technical assistance direction, he can demand information from you, but you can't disclose what you learn because of that demand, right? The things that happen as a result of that demand. So I argued in my op-ed that he could actually use information gained from investigating other politicians or other people with influence and power. Theoretically, he could abuse that information and we wouldn't know.
Yeah, so I think when you try to challenge a minister's exercise of their powers, there's always this challenge of how much do you know in order to be able to challenge that. And I think someone in the chat also asked, does this lady, I presume it's me, mean that if the minister uses the directions for an ulterior motive, the minister can be challenged? I think it is definitely very difficult to get information about motives. So this will only come up if you have some correspondence or certain documents, let's say public statements that the minister has made to prove that there were indeed such different considerations, you see. Yeah, in which case you would be able to try to launch a court case, maybe by seeking a declaration that the powers were not exercised properly, or to quash the directions.
Right. But yeah, that sounds like a really difficult, given that we wouldn't even know if he did it in the first place. Okay. Let's come back to the politicians. Thanks, Carol. And so someone asked, how may we help to gather more ground support for opposition against this bill? So politicians, what would you like people to do? How would you like people to help you? How do we rally support? against this bill, either to increase the amount of time, which is what you're proposing, to amend it, which is what the Workers' Party is proposing, or just to get rid of this bill entirely, which is what a lot of civil society is proposing?
I think for people to genuinely care about the implications of this bill, they probably need to see the implications of this draft bill and the link to some of the issues that they might be immediately concerned with. So if we recall in the immediate outbreak of COVID and how that has impacted on the foreign workers who are living in dormitories, that has actually found a deep resonance amongst many fellow Singaporeans about the treatment of foreign workers in Singapore. So with the implementation of this bill and with some of the activities which could be circumvented, because like I said earlier, what does constitute political ends and political means are very, very broadly defined. So if that is going to limit the research work and the kind of groundwork and challenges that NGOs and civil societies can raise on these issues which are important to Singaporeans, I think that's one way for them to realize that the limits which are going to be withdrawn from them would be severe insofar as it's going to limit the work of civil societies. So I think that's probably one area we can further look into, quite apart from the petitions and the online discussions, which are already ongoing on a great momentum.
PJ?
Yeah, go ahead, Manboy.
Yeah, okay. One thing I want to stress is that as responsible politicians, our role is to really inform the public, inform the Singaporeans of what is happening with facts and information. We also do not want to incite or instigate, people to rise to action, and that kind of thing. But after today's seminar, and also with the various quality information that has already come out into the social media and into the mass media, I hope Singaporeans can understand the implication of this bill, and more will speak up, more will respond to the post and the discussion in the social media for the remaining few days approaching Parliament, so that before we do the debate in Parliament on Monday, we have a very strong base of Singaporean support behind us, and we can basically, talk with more confidence in Parliament on Monday. So I think that's it. But of course, we don't want to sound that we are instigating or inciting, all these things. Okay. So, but I think Singaporeans should all start to take interest and understand the bill more and decide for themselves. Yeah.
Okay, but let's be a bit more specific. Give people one thing they can do. What if someone's watching this right now, they're like, oh my God, this law is terrible. Give them one thing that they can do right now to push back against this bill.
Maybe to send the some of the quality write up on the bill to more friends and family members, to widen the circulation so that there's a higher level of awareness. And then over the next few days, maybe whenever there are new posts in the social media and all that, participate in them and give comments. Yeah.
Okay, thank you. I think that's a good thing. Definitely, I think there was a survey after the last election that the more you had read political articles, taken part in petitions, answered surveys, attended seminars on political issues, the more likely you were to actually be participating in political debate and to vote opposition as well. So actually, I think that's raising awareness and debating with your friends is a good suggestion.
Yeah, and one more thing, PJ. For example, PSP is trying very hard, and we'll be posting a Chinese translation of a good piece written by a senior lawyer, for example, in Chinese. We have translated it. So, and we are trying to translate in other languages too. So maybe Singaporeans can help to disseminate the translated script to the other Singaporeans as well, those who do not read English well, and so that they got the information. Yeah. So the Chinese translation of that article is going to be on my Facebook and will be on the party's Facebook quite soon. Yeah.
Okay, cool. Thank you. So now we have a series of questions about the ISA and why we need this law when other instances of foreign intervention, like Huang Jing, Dixon Yeo, were used. The ISA was used to banish someone or to detain them indefinitely. And we also have POFMA, of course. What does this law actually do in addition to those other laws, one of which already blocks information and the other enables you to physically arrest anyone, with no proof? And then, of course, all the other laws, Telecommunications Act and the Penal Code. What is special about this law that isn't already covered in the existing statutes? Maybe one of the lawyers, would you like to answer that?
I think one, of course, is this broad definition of, covert actions on behalf of foreign principals. And so that's extending the link, if you will, to any form of support or any form of activities that might be foreign linked. Two, I think it's also a deep dive into the aspect of the funding for your independent social media sites. Of course, there are some legislations which do already provide for some of these limitations. But I think when you put up an entire legislation that's seemingly targeted towards limitation of foreign interference, I think that sort of gives it some level of legitimacy. So at the end of the day, I think it's a further ingress into the liberties of what a lot of civil society, independent media, and of course politicians, especially from the alternative camp, are trying to do collectively. So I think at the end of the day, one of the questions I've posed during the last election campaign is, when is enough, right? I mean, first of all, you have the Public Order Act, which already defines one person to be sufficient to constitute an assembly. And then there is the enactment of POFMA, and now potentially you are going to have an enactment of FICA. At the end of the day, I think one question, which I think it's more reflective, and probably this should be considered by the authorities in deciding whether or not they want to eventually enact, whether it's FICA or legislations of similar nature, that in trying to attract global talent, in trying to build Singapore as a financial and IT hub and intellectual hub, you are going to attract people who are going to be critical. And that's fundamental to any form of enterprise, any form of intellectual activity. And so if your legislation is going to be an enacted countermeasure to that, which you say is fundamental to your economy, right? And now that you are extending that balance to include even foreign entities and foreign individuals, then at the end of the day, where do you as a government that's trying to do its best for the people move forward? Because on the one hand, you want to draw in the activity with this global talent who are going to come with diversity of ideas, diversity of sometimes political ideas as well, but generally they are going to be critical of your system. And that's essentially what you want, because to be entrepreneurs, to be innovators, that is the prerequisite. You have to challenge the status quo. And if by law you are going to erode that and you're going to make people suspicious of whether or not they can continuously question the status quo, then I would say that at the policy making level, there are two inherently conflicting principles that I think they would first have to resolve a matter of principle.
Yeah, so I can offer my thoughts on how I think the legislations are different. For the ISA, it allows for detention without trial, right? So basically, a person can be detained, and it's meant to be more, according to the government, it's meant to, prevent these persons from posing a danger to society, and also it's meant to rehabilitate them back into society. But I think where FICA bill differs is that it's meant to be more punitive, as you can see from the sections 17 and 18 offences for foreign interference. The punishments are very high. It's up to 7 and 14 years. So it's really meant to punish the person after the person goes through the courts, and is found guilty. And how FICA differs from POFMA is in terms of the directions. So I think the requirements in POFMA are much stricter in the sense that POFMA directions can only be issued for false statements of fact, and when the minister is of the public opinion, that it's in the public interest to issue the direction. And of course, false statement of fact is more of an objective statement where you have to, where there has to be the requirement that a reasonable person would deem that information false, and it's not supported by facts. So in that sense, it's harder to issue a direction in POFMA because under FICA, what the minister has to do is to suspect that the activity is being undertaken on behalf of the foreign principal, and the material is published in Singapore, and it's in the public interest to authorize the issuance of the direction. But then we've mentioned earlier also, public interest is defined very broadly in the FICA bill. So that includes anything that could influence, anything that could be directed towards, it is prejudicial and directed towards a political end in Singapore. And that involves influence of political activities or publicly controversial activities and issues in Singapore. So the public interest consideration in the FICA bill is much broader, and therefore the minister has more discretion to issue that stock communication direction.
If I can pick up on something you said, Wendy, there's this huge contradiction where, on the one hand, the Prime Minister has said we need more foreign investment, but on the other hand, he says we don't want foreign funding. Then he says we want foreign participation in our society, but then on the other hand, he says we don't want foreign interference. So, as politicians, how would you address this contradiction, this very clear contradiction from the PAP, and what's your position? I know you've been in the headlines about issues regarding free trade, for example, but how do we draw this line what is foreign interference really, and what is foreign participation?
I think that's a very good question. And at the end of the day, it's a measure of what is the real risk you are trying to protect Singaporeans from, right? Because to take 3 steps back, that because hypothetically, if you're an independent media and you're getting funding from a foreign entity, and you would thereby publish matters that would influence political debates and thereby cause a change that's to the detrimental of Singaporeans. That's actually 3 steps back, and it's actually an extremely tenuous link, right? So at the end of the day, if there is such real risk that you could be getting funding, even at the extreme end, that you could be getting funding from a foreign political entity that has interest in pursuing Singaporeans or policies to be driven in a very specific way, you have to really understand, does our political process even allow that? If we're just taking the bare risk that they are trying to prevent, right? Foreign interference in politics. That at the end, if we can just summarize in a nutshell, if you look at the current makeup of Parliament, we already have the incumbents in control, and in that sense, ready to push forward certain bills that they think would be in the interest of Singaporeans. A lot of policies, whether it concerns COVID, in the current situation, whether it concerns healthcare, whether it concerns education, all aspects of Singaporean lives are already being considered, debated, and various policies, various laws are already implemented with certain thinking, with certain policies, with certain groups of ministers, parliamentarians who already hold certain views about how Singaporean life should be governed, right? And with the GRC system, that is unlikely to change, and which is still a major political hurdle for anyone in the alternative camp trying to even get a footing in parliament. These are already massive hurdles for anyone to try and make a difference in policy making. So if you just look at the reality of politics as they are in Singapore, and whether any form of online or social media influence could impact potentially in setting a different tone and different direction for policy making that would fundamentally undermine the interests of Singaporeans. I would say that at the very least, the reality of Singapore politics as we know it today probably is not at that juncture where we need to push through this bill in a rush of 3 weeks. And whether that risk can fundamentally come out in a different occasion, a different time, in a different space, that is never an impossibility. But if it does ever come out, then perhaps it'll be another time in another space where a bill such as FICA may possibly be reasonably considered with the appropriate measures and balance. But I would say that in the current climate as we know it in terms of policy making, the draft bill as it's currently presented is probably premature in its form.
Okay, cool.
Does that make
Spoken like a lawyer and a politician.
But talking
You're
about
very
how
cautious
that
on
varies
it.
in economics, I think the 60% of Singaporeans are generally happy with how their lives are being governed and ruled, and they have taken that decision the last election.
Well, okay. I have to stop you there because I've done videos arguing that that's not true because there's so much fear
we can
institutionally,
but
the way the
generally-
GRC system works, town councils, people are punished, so you can't say 60% or 70% just based on that pure thing. There's real fear out there, and academics have demonstrated that through surveys. Yeah.
Of course.
But then
but I think perhaps Manwai can add to it, but I think
Please, Manwai.
but PJ,
what's happening on the ground, that's probably my view of it.
Yeah, correct. PJ, but what Wendy say is still true, because whatever it is, the outcome is important, right? So the whole set of environmental factors in Singapore condition the results into 60%, 40%. 60% in favor of the incumbent and all that. And mind you, in Singapore is that, you don't need to have 60% actually to become government. In fact, you don't even need 60% of the vote to become an absolute majority. Absolute majority in Singapore means 67% of the seats. But currently the government has 87% of the seats. Okay. So actually, there's also this first past the post system that, that favors the incumbent and all that. So the whole system is there. So while you may say that Singaporeans inside, they think differently and all that, but then I think what is most important for politics in Singapore, for political change in Singapore is that, the sum total of the effect of all these factors still created the results of today. Yeah? So to come back to the question you asked about what is the difference between foreign interference and foreign participation, basically is whether you're for or against them, right? So as long as you're a foreigner, you come in, you speak in favor of all the policies that are in Singapore, then you're welcome to participate in our public discourse. But if you come in and directly or indirectly you help some Singaporeans to understand the situation from an alternative perspective, that there could be improvement done to certain policies and all that, and you try to reflect those things in the public discourse, then you become foreign interference. So that's very simple and really very straightforward, in my opinion.
Oh, thanks, Manwai. I'm so glad you told it like it is. And it's really refreshing to hear a politician just actually tell it like it is, because that I think Yeah, it's really good to hear you speak so directly.
Yeah.
Okay, so I have some questions here, which are actually, okay, first of all, about fundamentally, given that there's no chance of this not passing, and also another question about the difference between FICA and ISA is that ISA is seen as evil, and FICA so far is, it'll be new, so people won't know how to deal with it. So this suggests that ultimately this really isn't about security or interference. It's a political issue about what Singaporeans can accept, or and what the PAP can get away with, right? So how do you plan to? Do you agree with this, and do you plan to address this as politicians in your campaigns? Telling people, helping them understand that these are actually fundamentally political issues, not security ones.
Yes, I think that's what we are trying to probably present in Parliament on Monday. Yeah.
Okay.
Yeah, because we won't be dealing too much about legal aspects of the thing. Like I've told the minister in the last debate on the foreign manpower and FTAs, or that Parliament should not be just a legal interpretation forum. It should be a forum to discuss about the future of the country, and so we should be discussing from a social economic angle, from the angle of ordinary Singaporeans can appreciate, what impacts their life directly. So we hope to be able to do that in our presentations in our debate in the Parliament on Monday, and also in the future.
I just wanted to add on that, the press releases by the Ministry of Home Affairs have presented the FICA bill as a bill that's very targeted against foreign interference, and in particular hostile information campaigns, really making it look as though it's about foreign governments having some form of interference in our country. But the reality is that the language of the bill is far broader than that, because even influence can be considered interference under the bill. And influence can take place in many forms. It could be in the form of discussions as well, especially when you consider that collaborations with foreign entities and individuals are also captured under the bill. So I think in that sense, it brings it much wider to just the interference from foreign governments, which I think really that's the nut of the issue that we want to see addressed. And I think that's what's being addressed in the world today as well, that interference by foreign governments is the key issue, I think, that we should focus on.
Yeah, so thanks for bringing that up. Actually, there's a series of questions about this foreign aspect. Does this law doesn't actually stop foreign interference. It only criminalizes Singaporeans who are proxies for foreign interference, right? So there's no way this law actually stops, China, Russia, whatever other country running a hostile campaign from abroad. And one might say, okay, the directions, aim to stop this, but it doesn't then punish those governments at all. That's accurate? Is that accurate?
Yeah, I mean, it doesn't punish governments.
We can't punish
the individuals who carry out, and it tries to stop the interference from happening, and preventively as well, because there are anticipatory directions. For example, you can restrict certain accounts if the minister has a suspicion that a foreign principal is involved, and there are going to be certain online communications activity undertaken on behalf of that foreign principal.
So I think there was an article that came out was it yesterday, that Facebook notes that, okay, so we agree foreign intervention bad, but most of these information campaigns that we see in Singapore are actually domestic. And there was another article from Kirsten Han's We the Citizens newsletter, which showed that Chinese newspapers actually hew very closely to the Beijing government line because they want to expand their audience in China and get more, for advertising, for more readership. So it isn't even deliberate foreign intervention. They just parrot the line because they want to make money. How on earth do we address this issue? How do we, if like information campaigns are domestic, and if people like willingly do like speak on behalf of foreigners to make money, and there's no way to find someone actually campaigning or coordinating this, right? Then how do we address these campaigns? Open question to anyone.
Yeah, PJ, can I come in? Yeah.
Sure, yeah, please.
Okay. I think really at the end of the day, our thinking is that you have to empower Singaporeans. You have to give more information to Singaporeans so that Singaporean can make the judgment. As it is now, we Singaporeans are already quite intelligent. Okay, we can actually decide for ourselves. Okay, so no matter what kind of campaign foreign countries do against us, I think we have the ability to assess the information. And if certain information campaign really becomes very big, we are a relatively small country. We straight away can identify, oh, that campaign is actually getting a bit out of hand. Then it's up to the government to come in, give more information, explain to the Singaporeans that this information is not correct. And given that the government commands a high level of credibility still among the Singaporeans, I really don't see how we need to tighten, the hold on the Singaporeans with this new bill. The thing that government should be doing is really to promote better information so that Singaporeans know more, what is going on, and even maybe the government can even share some of the security threats that are threatening Singapore, give a little bit more information so that we get more aware. And the more aware Singaporeans are, I think we are a very disciplined, intelligent, and resourceful people. I think we can actually guard our country against foreign interference.
Well, thanks, Man. I think that's 180 degrees from how the PAP sees the country.
Right? Yeah, of course.
We're not intelligent or mature enough to handle any of this information, doesn't want us to know any of it. And just
Which is a sad thing, right? Yeah.
After 60 years in power, that's who we've become. If we're actually how they describe, they've been in power 60 years. They're the ones who molded us this way.
Yes.
Okay,
yeah.
So we have about 8 minutes left, and I just want to encourage everyone to send in any final questions. While we're waiting for those, there is another dimension. We're talking about foreign, right? But are we falling into a sort of trap here? Because we are keeping this debate and this campaign entirely domestic. Whereas other campaigns freely draw upon international dimensions, especially when, say, the government talks about certain issues and they're like, Singapore is so good in X, Y, and Z, right? We get lots of praise from foreigners, or we ally with these other countries, or other countries praise Singapore, or they say, Singapore's an example of a country. So the government is easy. They draw upon our international connections to show the success of their policies and to justify a lot of things that they do by comparing us to other countries or drawing upon examples elsewhere. But because of this narrative, we don't want to be called like collaborating, with foreigners, proxies for foreign intervention, whatever. We restrict ourselves domestically, right? So is there an international dimension to this that we're missing, where with new anti-foreign intervention laws being passed around the world, for example, or speech being clamped down, could the PSP collaborate with political parties elsewhere, international NGOs, to broaden the debate on this? Because this is as Gary Rodan has shown in his work, the only thing that the PAP really, really, really responds to and is very sensitive to is foreign investment. And the irony, right? They're actually very sensitive to the levels of foreign investment, to foreign capital, and to capitalist profitability for foreign companies. So could we, for example, ally with foreign organizations who are worried about this law, alongside NGOs and ASEAN parliamentarians for human rights, for example, right? We're not even talking about the West, we're talking about ASEAN parliamentarians for human rights has campaigned on various issues. They called our elections unfree and unfair, so are we falling into a trap by the PAP to restrict ourselves when actually we are in one of the most open, globalized societies in the world?
PJ, what you described, right, is exactly what FICA is going to catch, right?
I was going to say.
But I think then again, we don't know, right? Because it's up to the minister's discretion. So catch some, perhaps.
Potentially, Carol, potentially, yeah.
But that's the thing, he wants to scare you into not drawing upon resources and allies around the world, when the PAP draws upon its resources and allies all over the world,
Absolutely.
in particular international capital.
Yeah, so it's back to your question just now about foreign interference and foreign participation, right? They can draw on all those things. And very often the foreign accolades that we get from overseas, very often they tell half the story. Okay, they don't tell the whole story. Okay, like for example, our university ranking, for example, we may be ranked very high, but it don't seem to have much spin-off effect on our economy. Why is that so? They actually have to give the complete story. The complete story is actually to get a high ranking in the university ranking, you need to have professors who have written a lot of papers that have a lot of citation. Okay, the more citations your university professor have, the higher rank your university is. That is one of the key factor. Okay, but of course there are other factors, but that's one of the key factor. So in order to get our university into the high ranking, what do? Buy or bring in all those foreign professors that already got a lot of papers written, a lot of citations, and bring it over to our university, and straight away those citations become part and parcel of the assets and the advantages of our university. But all those things doesn't have the spin-off in developing our Singaporean talent, and actually meeting the needs of our industry. So you see some of these, besides this, there are lots of examples that, even those foreign accolades that they talk about, actually, they are half the story. We have to actually look at what is the real effect on in terms of generating benefits for Singapore and for Singaporeans.
Okay, thank you. I just want to quickly reply to a comment which says ASEAN parliamentarians for human rights. Have you looked around ASEAN's record on human rights lately? And note that ASEAN parliamentarians for human rights are overwhelmingly opposition parliamentarians around the region trying to improve ASEAN's record on human rights. They're not ASEAN governments, and it's not a it's not a governmental organization. They're actually an international regional NGO. Okay, so they actually do important, really good work. Okay, so I think there's a last series of questions very quickly about the next elections, and are we worried, for example, that FICA will be used to prevent opposition politicians from running in the next elections or affect the next elections the way POFMA was used in this past election? And is there anything that can stop that? Anyone?
Well, if the bill is passed, then potentially the risk will be higher. Like I say just now, it will probably set back the process by 5 to 10 years. And but we can't help it because right now the incumbent has such a super majority in the parliament. Yeah, the risk is there definitely.
Okay. Okay, so I think we've only got about 1 minute left. Would any of you like to make any final remarks or any final points? Wendy, maybe you can go first. Is there anything you'd like to sum up?
I think a link to your earlier question about whether there's an international dimension to this that we're missing out. In some sense, while the legislation is phrased as one that's for prevention of foreign interference, fundamentally, I think it's looking at building a relationship of trust domestically. right? I think it's when there's a relationship of trust between the people and the government, then whatever information that you're going to get from foreign directed sources, that is less likely to undermine your level of trust domestically if you are having that strong relationship to begin with. So I would say that focus on building policies and measures and directives that would foster that trust than to enact legislation that will undermine that trust. Because when you continuously erode that trust, then whatever means that foreign principals or agents are going to have to bring in news or information that will undermine that trust would take on a more significant and sinister effect. So my reflective thinking is really a more fundamental one. How do you build on that relationship of trust than to try and bring out all these legislations that will compromise that?
Thank you. Manwai?
Well, I just hope that Singaporeans and will try to understand more about this bill. This is yet another bill that will probably be very sensitive to a lot of the activities that both ordinary Singaporeans and politicians want to do going forward. I think it is a bill that is even more important than POFMA. It has a political dimension, probably that is even equal or bigger than the reserve presidential election amendment bill. So I hope Singaporeans will look at all these things, and then hopefully in the future we can chart the direction of our country differently. Yeah.
Thank you. Carol, any final remarks?
I want to echo what Manwai and Wendy said. And I think how this trust with the government plays out will really depend on the upcoming parliamentary debates and also how this bill is later on exercised. I think our impression of the bill has already been formed by how there was an absence of public consultation with regards to this bill as compared to the public hearings that we saw for POFMA. And so really, there was an announcement 2 years ago that there is going to be legislation about foreign interference. And now this bill suddenly just comes out. And, someone had a question about how laws are passed. And, usually the government releases the bill 1 month before, and then 1 month later is debated. But I think in important bills, there is normally a public consultation process, however brief that might be. But in this case, there wasn't. So I think how the next week will play out is really crucial, and I would encourage everyone to speak up and to understand more.
Thank you, Carol. Okay, so that's all the time we have left, and I want to thank Carol, Manwai, and Wendy for joining us today, and to thank my producer Kelly behind the scenes, and to thank all of you for joining us. And if you do want to educate yourselves, there's no better way to do it than to sign up as a member of New Naratif. Just $52 a year, but if you can't afford it, just write in and we'll have another member sponsor your membership. So it's free sponsorship at newnaratif.com. But to join, newnaratif.com/join, and to donate, newnaratif.com/donate. And I want to reassure everyone, no matter what happens, New Naratif is not going anywhere. We will continue to fight, we will continue to tell the truth, and we will continue to bring you our award-winning investigative journalism, our podcasts, our events, our comics. We will keep fighting. So thank you very much, everyone, and good night.
Thank you.